This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Michael Angelo Centeno. It's case number 2023 CR 300026. Brett Sweeney appears for the state of Kansas. Joseph Favre is defense counsel. The defendant, Michael Angelo Centeno, appears at the Butler County Detention Center's Zoom location. I also have present Sharon Teal from the Court Services Office filling in for the pre-sentence investigator, Carrie Seeley. This matter comes before the court at this time for sentencing. It would appear that the defendant appeared before this court on May the 3rd of 2024. At that time, he pled guilty to count 1, possession of methamphetamine, a severity level 5 drug felony. Court ordered a pre-sentence report and set sentencing for today. Court has received a pre-sentence investigation report compiled by Ms. Seeley. I trust each attorney also has had access to this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated therein?
No objection, Your Honor.
Any objection by the defense, Mr. Favre?
I reviewed it with Mr. Centeno. We have no objection.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score A, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in this case this morning?
No, Your Honor, I'm not.
Mr. Favre, are you aware of any such legal reason?
I'm not, Your Honor, no.
Mr. Centeno, do you know of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No, Your Honor.
Court will proceed further then. Counsel, I am aware that there is a departure motion before the court. It's entitled Request for Durational Departure Findings, submitted by Mr. Favre to the court. I'm now familiar with its contents. You may proceed further in regards to this request, Mr. Favre.
Judge, the bulk of the argument is listed in the motion, which is that Mr. Centeno has a criminal history that's severe. However, it's severe out of just one case. They are person felonies, but they all occurred at one time. He does not have a lot of entries on his criminal history as far as number of convictions relative to what we see from other defendants anyway. He is 30 years old. He has some potential for rehabilitation. The agreement is agreed upon by both parties. And I think part of the reason for that is that Mr. Centeno has a parole hold. He's had this entire time. And so even if the court were to grant him a departure, he would need to go to address his DOC hold. So he's been in custody for a very lengthy period of time for this case. It was a simple find of methamphetamine. It wasn't anything that was, it wasn't a very exciting fact pattern where there was violence or anything involved in that. I would add something that's not listed in there is Mr. Centeno is also a father. He has 3 children, 17, 14, and 9. He lives in Wichita. He needs to get back to try to support them. It's been a very long time since he's been able to do that. He has worked fast food in the past, although he's been trying to work construction lately to improve his ability to provide for his family. So that's something we'd also ask the court to consider factoring in when looking at granting his durational departure request.
All right, Mr. Favre, did you read your departure motion before you submitted it?
Yes.
Did you think it through before you submitted it?
I believe so, yes.
Well, look, let me address my concern here. Here's what you appear to be asking for in your motion. That you state that you want the court to grant your request for a durational departure and then place the defendant on probation for this offense.
Oh, yes, okay.
You see the fundamental flaw with that request?
I absolutely do, Judge, and I just missed that. Yes, I apologize. That was a mistake on my part.
Okay, so here's what I understand you're asking for. I'm going to address Mr. Sweeney in a moment as to why Mr. Centeno gets this special treatment. But what apparently you're asking the court for is to take a sentence which was intended by the legislature to be at least 3 years in duration, bust it down to 8 months, give him credit for time served and turn him loose?
Judge, we are asking for a durational departure to the time served. That was the agreed upon recommendation as part of the plea, yes. And he's been in custody for a lengthy period of time. Yes, it's not nearly as much as the legislature intended. But I also think that there's other factors that weigh in that support maybe giving him such an extreme, extreme cut in time, and that we've tried to outline for the court.
All right, Mr. Sweeney, then I will turn to you. This is an extraordinary plea agreement in the view of the court. You're generally very fair. I'll state that for the record here. On the other hand, this is really an extraordinary plea agreement that was reached to essentially only require about a fourth of the time which the guideline sentence would otherwise call for. Why special treatment for this individual, Mr. Centeno, above every other person that comes through this court system charged with this serious felony crime?
Thank you, Your Honor. Your Honor, as I would tell the court that we always try to stay uniform for the most part in our recommendations for individuals. And I hate really, in large part, the reason that the state has cut Mr. Centeno a break is the large amount of time that he has served in custody, the 241 days up to this point, but maybe even greater in the state, and what it's factored into this decision is essentially the fact that this is such a small amount of methamphetamine. It was 1/10 of 1 gram, so 0.10 grams of methamphetamine, probably just a little bit more than residue. I think it's still certainly obviously methamphetamine. And so still something that I think the state takes pretty seriously. That being said, I don't make the substantial and compelling reasons, but it was part of the plea agreement that the state would join in the durational departure to the time served, with the understanding that he still would have the post-release supervision. The state's still asking that this case run consecutive to the 17 CR Sedgwick County case, with whatever's left of that. And I'll have to be honest with the court, I'm not sure exactly where he stands with his completion of that Sedgwick County case. But it's also my understanding that, yes, he still has parole DOC holds as it relates to this.
Anything further, Mr. Favre?
No, that is correct. And I did fail to mention the quantity, which was a big factor as well. So I'm glad Mr. Sweeney mentioned that.
Very well. That will conclude the departure hearing portion of this proceeding. The court will move on. The court at this time would ask if there's any victim or members of a victim's family present who desires to address the court in relation to this sentencing. The court finds no such persons present. So at this time, the court will ask for formal recommendations from counsel regarding an appropriate sentence for Mr. Centeno. Mr. Sweeney, what are your formal recommendations?
Thank you, Your Honor. As previously noted, the state is recommending or would be joining in the durational departure for a sentence of 241 days in custody. As we previously noted, we believe he served that. We would note that the maximum good time percentage, for what it's worth, would be 20%. I do believe the post-release supervision duration is noteworthy, and I think that would be 12 months. The state is not asking that the defendant be placed on probation, as is previously noted, so it wouldn't necessarily be a dispositional departure, but only a durational departure with a sentence effectively served. The state is requesting the court costs in the matter. We're not requesting a fine. There was a KBI laboratory report that was completed, so we're seeking $400 in restitution for that. Of course, we're seeking inquiry into the bids and attorney's fees, if those are appropriate. And we're also asking that this case run consecutive to that Sedgwick County case. And that case number on that is 17 CR 821. And that's all I have, Your Honor.
All right. Thank you, Mr. Sweeney. Mr. Favre, your formal recommendations regarding an appropriate sentence?
Judge, we join with the state in those recommendations for a modified sentence of 241 days. I will note that the court's correct that my motion incorrectly requests for probation. Just to be clear, we're not requesting a probation sentence on this based on the motion filed. We're requesting a durational departure. No objection to any of the costs or fees listed by the state. We would ask the court to consider waiving his attorney's fees. Mr. Centeno has been in custody for a long time. He also, as noted, has been working fast food jobs prior to that. So we don't know how long it's going to be before he gets out on his parole hold. But when he does, he'll need to start working and paying off the extensive fines he'll have. So we'd ask the court to consider waiving his attorney's fees.
Very well. Thank you, Mr. Favre. At this time, the court will address the defendant, Michelangelo Centeno, personally, and I'll ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Centeno, if you've got anything to say to the court, you need to say it now.
Your Honor, I speak very fluent English right now, so I'm just gonna try to say, that's pretty much all I have.
It would seem to the court that kids and methamphetamine don't mix very well. Would you agree, Mr. Centeno?
Yes, Your Honor.
Quite frankly, counsel, the court is struggling with this plea agreement. This is an unusually favorable joint recommendation that's been made. I think I've already made that comment. It's really extraordinary for the prosecutor's office to make a deal like this, where they're joining a defense recommendation for such of a reduction in the overall sentence in the case. I will note, and I think it's fair to note, that it's his criminal history which causes the time to be so large for this drug crime. Most possession of methamphetamine cases involve a much less amount of controlling sentence than there are in this case, but that's one of the implications of being in the A box, which is the worst criminal history that a person can be in. Mr. Centeno, it also bothers me that you want to get back to your kids, yet you got yourself, as a convicted felon, you got yourself involved with this dangerous street drug of methamphetamine. I don't really care about the quantity when it comes to the principle that we just talked about, that methamphetamine and parenting do not mix. Maybe 8 months locked up in jail have reinforced that principle for you. Maybe the prospect of spending 3 or more years in prison has locked that in for you once and for all. I hope so. Court hereby establishes count 1 as the base sentence in this case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of A, thus placing him in grid box 5, drug A. Court hereby sentences the defendant to a departure term of 241 days in the Department of Corrections custody. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed here, as this was not a financially related crime. Court has, implicit in its ruling, granted the request for a durational departure for the reasons stated in the request, the long period of time since his previous criminal offenses, that it was an agreed upon disposition that the state joins in. It's been a compelling factor in the case. The court also is somewhat assured that he's going to face justice in relation to a Sedgwick County case. The court has considered that as a reason, and that the quantity involved ultimately is a factor that supports a mitigated sentence. The court does find substantial, compelling reasons as a result to grant the durational departure sentence. This, in essence, flattens the time. The court does order that this defendant actually do 12 months of post-release supervision. Ms. Teal, I know you're filling in for the pre-sentence investigator. Could you use the resources of your office to contact state parole and make sure that they're aware that this court is actually ordering the post-release supervision? There are times that in the past where I've heard that they want to know specifically that a flattened sentence still has a post-release supervision period ordered. I certainly want Mr. Centeno on a supervised release program stemming from this case. So anything that you could do to communicate that to an appropriate state parole office would be greatly appreciated. Do you need any further clarification on that, Ms. Teal?
No, sir, I'll do everything I can.
All right, thank you. Court will be assessing a felony docket fee to this defendant and $400 KBI laboratory fee in light of the fact that he is not going to be released apparently because of the parole hold out of Sedgwick County. I'm not going to assess bids amounts. I don't know when he's ever going to get out and what kind of work he's going to be doing. I just don't have enough information to assess those fees. So obviously, Mr. Favre's skills and abilities have been greatly beneficial to this defendant. So all bids amounts are waived. I'm going to declare all of these amounts immediately due and payable. There will be a recommendation to the state parole office on the post-release supervision period in this case that I recommend a substance abuse treatment program be required and successfully completed by this defendant while on post-release supervision. If you wouldn't mind communicating that, Ms. Teal. If you can include that in the sentencing journal entry. Mr. Sweeney, understanding, of course, this is a recommendation from the court to state parole.
Yes, sir.
This sentence is run consecutively to Sedgwick County case number 2017 CR 821. Even if this court were not required to do so, the court would do so in this case as a matter of discretion. As stated earlier, the sentence is flattened. The defendant is credited with 241 days of jail time credit in this case and applied to the DOC sentence, which essentially flattens it at this point. Some point in the future, Mr. Centeno, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant has a right to appeal their conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. And you do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there are prohibitions against a convicted felon possessing a firearm, and there are losses of certain civil rights, such as the right to vote until your sentence is fully discharged. I'm looking at my notes from this proceeding, Mr. Sweeney, and I'm trying to determine if there's any other sentencing related matter that I need to address. Is there any other ruling that you're asking for at this time?
No, Your Honor.
Mr. Favre, is there anything further that you believe the court needs to address?
No, Your Honor.
Okay. Mr. Centeno, do you have any questions about the court sentencing orders?
No.
Okay, let me tell you where you stand right now. As of this moment, you're released on this case.
Okay.
But you do have a hold apparently out of Sedgwick County. You're going to have to take care of that.
Yes.
Then you need to get out in the community and you need to put methamphetamine in your past and never touch it again.
Yes, Your Honor.
good luck in that regard. I hope you make it, and I hope you're there to be a support system for your children.
Yes, Your Honor. Thank you, Your Honor.
Ms. Teal, did you need anything further?
No, Your Honor.
Okay, thank you. I appreciate your involvement here today and your work on behalf of the court.
Thank you.
If there's nothing further, then the Michael Angelo Centeno matter will currently be in recess, and this meeting may be ended for all at this time.